Okay, and we are back in business with the slides. Right. So as I said, I'm here with my co-facilitators, Melanie Marsden Myers and Diane Wintermute, to deliver the workshop today. And I want to first get things started by handing things over to Melanie to do a land acknowledgement for us.
Okay.
But before I did that, I just want to make sure we're not having any other difficulties accessing the interpreters. I know we did circulate an email a few days ago, and if you are having difficulty accessing, please send a message in the chat, and you will be connected to our staff who are behind the scenes. Okay, Melanie, I'll turn it over to you.
So we respectfully start this workshop with a land acknowledgement. On behalf of ARCH, it's an honor for me as an Indigenous disabled person to offer the land acknowledgement. My name is Melanie Marsden Myers. My Indigenous name is She Carries the Light Woman. I am registered with Alderville First Nation. I am Ojibwe and Mohawk. And I am Bear Clan. I am blind or visually impaired. We acknowledge that participants attending this workshop are situated in various communities across Ontario and in other provinces. As we watch trees change for fall and animals readying for colder weather, we are aware of nature and the importance of caring for it. We further acknowledge that the first peoples of Canada have been the stewards of this land for at least 12,000 years. And we honor the contributions that Métis, Inuit, and other Indigenous peoples have made both in shaping and strengthening this province and the country as a whole. We who sit at this table are aware of our role to peaceably share and care for the resources around Ontario Great Lakes, as set out in the Dish with One Spoon Wampa Belt Covenant and agreement between the Iroquois Confederacy, the Ojibwe, and allied nations. For those who are settlers, they are grateful for the opportunity to live, play, and work here. We thank all the generations of people who have taken care of this land upon which we meet. This recognition of the contributions and historical importance of Indigenous peoples must also be clearly and overtly connected to our collective commitment to make the promise and the challenge of truth and reconciliation real in our communities. In particular, we commit to bringing justice for murdered and missing Indigenous women and girls, transgender, trans-identifying, and two-spirited peoples. Today, on behalf of ARCH, it has been an honor to offer the land acknowledgement as an Indigenous disabled woman in the spirit of creating an inclusive, safe space where people presenting can be part of honoring the presentations, engaging in conversations, and moving the employment conversation forward in a respectful, safe, caring way in which we know that we are all doing our part in the best way we can. I thank other Indigenous peoples who have expressed this land acknowledgement and given me permission to build it and make it my own and share it with everyone this evening.
Thank you, Melanie. So before we get into the workshop, I wanted to give everyone an overview about all of the things we're going to talk about tonight. First, we'll deal with some of those necessary housekeeping items. Then we want to talk a little bit about, or tell you a little bit about this project and some of our goals of this project. Then we're going to talk about laws about disability in employment. And that's, of course, the bulk of the work that we're going to do today and the reason why we're all here. Then we're going to take a 5-minute break where we will transition into the second part of this workshop, where we'll have an opportunity for people to ask questions and practice some of the things that we've learned tonight. So for the format of the workshop, the first half is a presentation by Melanie and Diane and I about the legal information about your rights when it comes to employment. The second half, as I said, we will be moving to a question and practice scenario where we will be moving all of the participants into smaller breakout rooms. Carrie, another lawyer from Arch, will be joining us later to lead one of these breakout rooms. There may be some other participants attending tonight who are from other organizations who are running similar projects like this one from other provinces. And they're here to learn about how we are putting on our workshop. We also note that some of you who are attending today's workshop are also attending our workshop next week, which is for employers. And so we just want to remind everyone that when you're here tonight, you are here in your role as an employee or a prospective employee. And just as a quick reminder, for this first half, we ask that everyone keep your audio on mute and your video turned off. And then once we go into the second half, there will be more opportunity to turn on your audio and turn on your video. And just for anyone who has missed it, this session has captioning and ASL. ASL interpreter will be available in a separate window throughout today's presentation and later in the breakout rooms. You can keep this video in view by pinning the video. So if at the top of the screen, you can hover over the video of the participant or the ASL interpreter that you wish to pin and click Pin Video. About every 15 minutes, we'll pause our presentation for an interpreter switch. This will give you time to pin the new video. Captioning also is...
Video appears to have frozen. Please wait for video and audio to resume.
We're behind the scenes. And again, we will ask you to save all your questions for the second half when we are in the breakout room. This workshop is being recorded, but we are only recording this first half. So it will be available on Arch's website in a few days. Now, the second half of the presentation, where everyone is open to ask questions and participate in a discussion, that part will not be recorded and will not be posted on Arch's website. The information we talk about today here is general legal information about disability rights and employment. Because of privacy reasons and relationships with lawyers, we can't provide you legal advice about how the law specifically applies to you. If you like to speak to a lawyer about how the law applies to your situation, there is some contact information for lawyers provided to you at the end of the fact sheet that was sent out to you on Tuesday. After the workshop, you will receive a survey, a link to a survey, pardon me. We will ask that you please fill out the survey. It tells us if you found the workshop useful and what we can do better. The surveys will be anonymous and will form part of the report that we have to send to our partner at the close of this workshop. So about this project, about Do the Right Thing. This slide has a graphic on the bottom of 9 hands that are raised up. They're all different colors, and you can see some of the sleeves. And so they're kind of indicating that they're putting their hands up. This slide is about sort of what we're doing here with Do the Right Thing. And it's a partnership between an organization called Dawn Canada and Arch Disability Law Center. Dawn is an organization that works to advance the inclusion of deaf women and girls with disabilities in Canada. And Arch, as you may know, is a specialty legal clinic that practices exclusive.
Video appears to have frozen. Please wait for video and audio to resume.
Disabilities and deaf women access employment through this project. The goal of this project is to create practical tools, educational materials, and public awareness campaigns on the human rights obligations of employers and service providers. This slide is about the 2 phases of our project, and it again has the same graphic of the 7 hands, pardon me, I think I said 9 before. The first phase, which we did last year, was where we ran a number of focus groups and key informant interviews and questionnaires, where we wanted to hear from women with disabilities and deaf women about their experience and their journey searching and maintaining employment. Phase 2 is based on the information we learned in phase 1, and this is phase 2 that we're doing today, where we're hosting legal education workshops on disability law in the workplace. We learned a lot in phase 1, but as a summary, we learned that many participants experienced violation of their rights in employment situations. We learned that people don't know when or how to disclose their disability, and that figuring out the right time to disclose is very stressful and takes a lot of energy. We learned that there needs to be more education for women with disabilities and deaf women, and also for employers and potential employers. We also learned that participants need more information about the source of their disability rights at law and accessibility laws, and how to use those rights and laws in their job journey. Where do those rights come from, and how can we use them effectively? Now that you know how this project has evolved, I want to turn it over to Melanie to talk a little bit about the goals of today.
So the goals of this workshop are to promote a solid understanding on disability rights in employment, to understand the roles and responsibilities of employers and employees, and to apply legal principles to scenarios involving disability in employment. In phase 2, Arch is hosting 2 workshops, so this evening. And the second one is on October 22nd to provide legal education workshops for employers and or service providers from 3 to 5. Arch is providing these workshops in both sessions for free. Arch has extensively outreach to many disability communities. And by that I mean in terms of flyers, vlogs, and the invitation once people have registered. So all of the outreach went to many disability community groups, deaf communities in Ontario, including but not limited to, we went to listservs, it was tweeted about. We also made sure that people and organizations that were connected to newsletters circulated our information, Facebook, networks, coalitions. The outreach also went to banks and universities and colleges and banks, and to employment agencies and employment networks, just to name a few of where the outreach went for this project.
Thanks, Melanie. So today we're going to consider 2 kinds of laws that impact disability in the workplace. Now there's lots of kinds of laws. We'll just ask people to save their questions for the second half of tonight. As I was saying, there are lots of kinds of laws, but the 2 that we're going to talk about tonight are human rights laws, which give persons the right to be free from discrimination and harassment. And that's a right that belongs with you as a person, and it carries with you as you go through about your employment journey. There's also laws called accessibility laws. Now, those laws set out the minimum basic rules that businesses have to follow in creating employment environments. There are Ontario human rights laws. That's called the Human Rights Code. And that's the law that says you have the right to be free from discrimination when looking for a job or working or going out to eat food or go shopping or even going to look for a place to live. It's if you're doing all of these things in Ontario, the Human Rights Code applies. Now there's another Human Rights Act called the Canadian Human Rights Act. And this is the act that says you have the right to be free from discrimination, but this is where the business or the agency is regulated by the federal government. So that means in things like banking, by Canada Post, or if you're traveling on an airplane. Now, for accessibility laws, I'll turn it over to Diane to explain these laws.
Hi, everybody. Similar to the 2 sources of human rights laws, there are 2 sources for accessibility laws. One provincial, which is the Accessibility for Ontarians with Disabilities Act, and one federal, which is the Accessible Canada Act. The Accessibility for Ontarians with Disabilities Act was unanimously passed by all parties in the provincial legislature in 2005. Its stated goal was to make Ontario accessible to persons with disabilities by 2025. How Ontario proposes to do that is to identify, remove, and prevent barriers or obstacles so that people with disabilities can participate more fully in their communities. As part of the AODA, which is the short form, that I'll be using from now on, the government has developed province-wide accessibility standards in key areas of daily life. There are 5 standards currently under the AODA. The first is the customer service standard. The second is communications and information standard. The third is transportation. Fourth is design of public spaces. And the fifth is an employment standard. The government is currently also working on additional standards, the healthcare standard, and then 2 standards in education, one from K to 12 and the other post-secondary. These standards set out the minimum requirements. They're the floor of the accessibility requirements for organizations in Ontario. The distinction between the Human Rights Code and accessibility laws, the AODA, are important to know. The Human Rights Code has primacy. It is the most important law in Ontario, and one that should influence the interpretation of all other laws. So they have to be, all other laws have to be read as being consistent with the Human Rights Code. The AODA, in fact, states that if there's a conflict between it and any other act or regulation, the law that offers the highest level of accessibility comes first. The Code and the AODA both use the same definition for disability, and Jess will be addressing that definition later. The AODA doesn't, of course, apply to federal government and federally regulated organizations like banks, airlines, and interprovincial transportation companies. Those are covered by the Accessible Canada Act or the Canadian Human Rights Act. The Code and the AODA work together, but they have some important differences. Under the Code, when a person with a disability needs accommodation, there is a duty to accommodate. And we'll get into this a little bit more in detail later. But the duty to accommodate means that organizations may have to provide an individualized response to an accommodation request. And I emphasize the individualized because everybody experiences disability in a unique and personal way. So when you're asking for accommodations, a proper and appropriate response would be to implement accommodations that are specific to you and what you need to have equal access to, for example, your workplace. The Code applies to all organizations, regardless of size. There have been some amendments to the AODA that ensure that almost all organizations have some responsibility under the AODA, but some of the accessibility standards and their requirements will only apply to larger organizations. And I don't want to get into too much detail about that because it becomes a little bit confusing. But just to say that there are some organizations that have to meet all of the minimum standards and others that may have an exemption from some of those standards. The Code applies to all Ontario organizations, regardless of type or size, and this includes owner-operated organizations. It also covers, the Code also covers volunteers and unpaid workers, unlike the AODA. Volunteers are not, and unpaid workers are not covered by the AODA. The AODA sets accessibility standards that the Ontario Human Rights Code helps to guide. The AODA requirements, the AODA standards don't limit or replace the Code requirements. And meeting the AODA minimum standards, and I want to say again, they're minimum, they're not maximum. So employers or other service providers can and should be encouraged to go above what those minimum standards are. But meeting the AODA standards doesn't guarantee that an organization has met its code obligations. Active rights, rights where you can seek an individual remedy, are found under the Ontario Human Rights Code. However, the AODA, unfortunately at this time, doesn't have a process or a mechanism to file individual complaints or get individual remedies. There are inspectors who are hired under the AODA to do investigations or assessments of organizations to determine whether or not they're meeting the minimum standards of the AODA. And there are some hefty penalties that apply if organizations fail to meet those standards. But the remedy for that is to fine those organizations and not to provide individual remedies. Okay, so the employment standard of the AODA requires that employers make their workplace practices accessible to potential or current employees with disabilities. The standard applies to paid workers, but not to volunteers. And the practices of employers in order to make their workplaces accessible range from recruitment or advertising for available positions, to the interview stage, to the workplace, the physical space itself, developing an appropriate accommodation plan, emergency responses, and leaves of absence and return to work policies or practices for employees with disabilities. I think I'm going to stop there and let Jess talk a little bit about the Human Rights Code.
Thanks, Diane. That was great. So important to think about the differences between accessibility laws and the human rights laws, as Diane has talked about. So we're gonna talk a little bit more about the human rights laws. So what does the Human Rights Code say? At its most basic, it says that persons with disabilities have the right to be free from discrimination and harassment in employment. So that's a pretty great, strong statement. Now, what does that mean? Let's talk about some of the different aspects of this sentence. So what do we mean when we say the word disability? This slide has a graphic on the bottom. Along the bottom is a number of people who look like they're from a number of different backgrounds. Some of them have visible disabilities, and they look like they're sort of having a party, their hands are up in the air, and they're having a good time. So if we go back to the definition of disability, it's very broad, and that's important to keep in mind. This means that many things could fall within the definition of disability according to the code. It could include disabilities that have a diagnosis, but it could also include disabilities that don't have a diagnosis. The Human Rights Code, right in the law, lists a number of things that could be a disability, like physical disabilities, intellectual disabilities, communication disabilities. But we know that the law says that disability is broader than that. So it doesn't have to be listed in the code for you to be protected by the code. It includes things that are episodic, disabilities that are episodic, which means maybe the disability only impacts your life or impacts you or expresses itself some of the time. And it also includes not visible disabilities. It even includes when someone else thinks you have a disability or treats you like they think that you have a disability. So that's called a perceived disability. So it even includes situations like that. Now, Melanie, did you have anything to add about the definition of disability?
Yes. When we are talking about disability, it's important to honor a person's identity. So I am speaking about Kimberly Crenshaw's work, who coined the term intersectionality. So because I can't speak on behalf of everyone, I will use myself as an example. My intersections are Indigenous, disabled, and female. To all identities of an employee need to be honored and respected, and even in some cases named, because again, in my case, I don't necessarily look Indigenous, but I am. So those identities of an individual make up a whole person, and they need to be honored by employees and employers. So this also includes race, gender identity, ethnicity, deaf and or deafened, just to give a broader explanation of disability and the intersectionality piece that oftentimes isn't named, but is so crucial to be named.
So important, Melanie, you're right, because those factors, those different intersections interplay with disability so often. And it's so important to make sure that that's part of our conversation. So the next part that sentence that I read out about, the right to be free from discrimination, what does employment mean? So in what kinds of situations does the Human Rights Code apply to protect from discrimination? And so this is also interpreted very broadly. It would include part-time work or full-time work, contract work, internships, and even volunteer work. So that's one of the things that Diane mentioned. So the code, when we're talking about human rights law, it does protect volunteer work, while something like the AODA might not provide does not provide standards in that area. And so no matter what your working situation is, it applies to all areas, all parts of your interaction with work. So all the way from the very beginning of the relationship, which is interviewing, submitting your application, and the hiring process, to job training, to pay, to benefits, to having equal opportunity to promotions, and then all the way through what hopefully doesn't happen, but the end of your relationship with your employer, which is termination. Melanie, did you have something also to add here from an intersectionality perspective?
Yes. So as I mentioned earlier, I spoke about intersectionality. And when people have intersecting identities, it's hard to understand which form of discrimination it is. However, discrimination does negatively impact emotionally, spiritually, physically, and the well-being. Without policies and procedures in place to prevent discrimination, it increases likelihood of discrimination. Experiences are oftentimes unspoken, or they're hard to identify and or to prove. We need to be believed when these things happen, And we need to acknowledge that they do happen without proof at times. So it's acknowledging the intersectionality, how it intersects with employment as a whole person.
Great, and that's a great transition to talking about what we mean when we say the word discrimination. Discrimination is when an employer treats you differently because of your disability, and that different treatment has a negative impact on you. Can be direct discrimination, where the action itself is clearly discriminatory. So, for example, if you saw a job ad that says, "We prefer to hire younger people," that's direct discrimination. Now, we don't see that kind of discrimination very much anymore. What we see most often is something called indirect discrimination, where it's, when you first read it, it might be a neutral rule or a neutral practice that actually has the impact of singling out a particular person or a particular group of persons. And that results in unequal treatment. So, for example, if we think about the example I have here on the slide, which says a job advertisement that says you must have a driver's license to apply. Now, this job advertisement isn't saying directly we hire a younger person or we won't hire a person with disability, but the way that this rule, must having a driver's license, has the impact of negatively impacting persons who may not be able to get a driver's license because of their disability. So Diane, can I turn it over to you to talk about accommodations and how we kind of respond to this indirect discrimination that happens in the workplace?
Sure. So accommodations are changes or things that are put into place to stop or prevent negative impact from discrimination. So they're those kinds of things that make your opportunities equal to others. Barriers at work could include physical barriers like inaccessible buildings, technologies, or workspaces, or non-physical barriers like attitudinal barriers, workplace rules, or job qualifications. And to go back to the example that Jess used a couple of minutes ago, if a job requires that a candidate have a driver's license, we can think creatively about how transportation, different modes of transportation, might be used to accomplish that same job duty. So think about whether that requirement can be addressed in different ways, like using a bus, a streetcar, a subway, a bicycle, walking, a train. There are lots of different things that we can think about in trying to address that requirement. The duty to accommodate has different components, different requirements. One is for the employer, and the employer needs to do all of the things that are included under this slide. Under the code, the employer has a legal duty to accommodate the individual or unique needs of people with disabilities when they can't perform all of the duties of their job because of their disabilities. The most appropriate accommodations will respect dignity, autonomy, be individualized, and allow people with disabilities to participate in their employment environment. The duty to accommodate is a multi-party process, which means both you and the employer and maybe your supervisor, anyone else that may be in a managerial position, need to participate in order to find the appropriate accommodations. And as we discussed earlier, the appropriate accommodations are the ones that address your specific or unique circumstances in order to have the equal benefit or access to your employment environment. Okay, the duty to accommodate also requires your participation. So, for example, you need to tell your employer that you need accommodations, and that's because if you need accommodations to equally access your employment environment or your job duties, you don't want a lack of accommodations to have a negative effect on your job performance. You want to avoid there being performance issues if you don't have the accommodations that you need. You want to participate in discussions about the accommodations because they're about you. And there's a part of the Human Rights Code that talks about two different kinds of accommodations. One are procedural accommodations, which means that the employer has to involve you in discussions about appropriate accommodations. Accommodations aren't static. They don't have to say the same, or they're not fixed. You can try different accommodations to see what works best for you. You may be required to provide more information about your accommodation needs from a healthcare practitioner who can speak to your needs, restrictions, or limitations. And that raises the issue of when do you disclose your disability to your employer? And I think Jess is going to speak to that.
Perfect. Thanks, Diane. Great. Perfect transition. So really big and important thing to think about is when and how you share that you have a disability. So as Diane said, it's a good idea and important to disclose your need for accommodations as soon as possible. But it's up to you to choose when and how many details you share about your disability. It's a good idea that you make your request for accommodation before you need that accommodation to be in place, because you don't want, as Diane said, to have, if there are, if what your employer thinks are performance issues, but the reality is you just needed some accommodations. You don't want to have the accommodations conversation when sort of come into play when you're about a performance issue, because there's nothing, you don't want to give your employer opportunity to question your ability. So sometimes when it might be appropriate to disclose your need for accommodation is before an interview, if you need the accommodation for the interview. You may want to do it at or after the interview, or once you get started in employment. One thing that is important to point out here about the AODA, which is the accessibility law that Diane talked about, is that requires employers to set out clearly that, for example, in an interview, do you need any accommodations? To ask anyone in an interview if they need accommodations. You are not required to share the cause of your disability or diagnosis with your employer. That information does not help the employer put the accommodation in place. And that's really the reason why you just would disclose that you have an accommodation need, is so that your employer knows that they need to take action to put the necessary accommodations in place. As Diane said, sometimes there is, the employer has the right to ask for more information about maybe your needs and limitations, but that's really most or only appropriate when your accommodation request maybe has some particular aspect that's complicated, and the employer can really establish that they need to know more about your disability to really put the appropriate accommodation in place.
There are very limited circumstances under which an employer can say no to an accommodation request. I just want to go back to something that Jess mentioned. I mean, employers should accept accommodation requests in good faith. They shouldn't need to require medical reports or other information to support accommodation needs, but sometimes that happens. And so the only time they can say no to those needs is if it would cause the employer undue hardship. Costs are one of the factors under the Human Rights Code that will exempt an employer from implementing accommodations, but those costs must be so high as to affect the business itself, because we don't want to put too low of a price on someone's human rights. So if an accommodation request goes to the viability or the essential nature of the employer then may have a defense to not providing an accommodation. But once again, you don't want to just accept somebody saying, I can't, it's going to cost too much. The employer needs to prove how the costs will affect the operation of their business. So it's a very high standard that an employer has to meet before costs can be a defense. Part of the costs defense is that the employer is required to look for outside funding to help pay for accommodations. So are there grants from the province or the federal government that an employer can apply for to assist in the cost of providing accommodations? The third factor that can be a defense to a refusal to provide accommodations is whether or not the accommodation would have a negative effect on the health and safety requirements for either the employee or for other employees that are specifically related to the accommodation request. The health and safety issue is one that I've been thinking about recently when it comes to products that are used during the pandemic and their impact on persons with environmental sensitivities. And we might be able to have a chance to discuss that further, but I think that balance or interplay between health and safety for both the employee and others that work in the same environment, I think that that's worth thinking about in terms of how to balance the needs of both parties and the employer, so 3 parties, in the accommodation process.
Yeah, Diane, that's such an interesting thing to think about. I mean, and it's something that I'm sure lots of people have been thinking about and I know that we think about it at Arch a lot, especially in COVID times when we're trying to say, yes, there needs to be safety precautions and safety measures put in place, but we need to make sure that we're not trampling or setting aside those fundamental human rights. So I think that's a really good example, Diane, of things that we need to be thinking really hard about right now. And, we don't know the answers and how things like that would resolve, but we really need to be thinking about it from a human rights perspective. So I think that's a really nice way to finish the first half of our workshop. What we will do now is we're going to take a 5-minute break.
Screen transitions to reveal 3 logos: Do the Rights Thing, Arch Disability Law Centre, and Dawn Canada, along with the text, "Discussion not recorded. Thank you for viewing."